Business law. Introduction to the module. Corporations created in accordance with the Companies Act of 2006 are governed by British legislation on companies. The corporation is the fundamental legal entity for business organisation and management. It is further controlled by the Insolvency Act of 1986, the UK Corporate Governance Code, European Union directives, and judicial decisions. Public corporations, which can trace their contemporary existence back to the late Industrial Revolution, today employ more people and produce more money in the British economy than any other kind of organisation. The United Kingdom was the first nation to create modern corporation statutes, allowing any investor to incorporate through a straightforward registration process, limiting their liability to commercial creditors in the event of business insolvency, and handing management off to a centralised board of directors. Topics to be covered in this module. Fundamentals of corporate law and corporate governance, statutory legislative law, common equity law, tort, civil law summary. Fundamentals of corporate law and corporate governance. The body of legislation known as commercial law regulates the rights, interactions, and behavior of both people and corporations. Common law and legislative concepts pertaining to business transactions, such as the sale of products, e-commerce, agency, and insurance, are included into commercial law. Company law includes company governance and corporate finance. Corporate governance in the UK binds shareholders, workers, creditors, and directors. Corporate governance is how corporations are managed. Corporate governance rules and principles recognize that people and organizations have various responsibilities, rights, and obligations and attempt to safeguard them. Fundamentals of corporate law and corporate governance. Basic principles of corporate governance. The Waits Code is a guide to excellent corporate governance for bigger organizations. The organization that designed the code hoped all firms, regardless of size, would embrace it to demonstrate excellent corporate governance. The Waits Code includes 6 guiding principles for business boards. Leadership, corporate purpose, governance, manager duties, risk and opportunity, remuneration, engaging stakeholders. UK Corporate Governance Code. The UK Corporate Governance Code is a collection of corporate governance guidelines for premium-listed UK firms. The 2018 code applies to fiscal years starting on or after January 1, 2019. First version of the code created in reaction to 1980s corporate failures caused by inadequate board supervision and control. The code only applies to premium listing corporations, although lesser businesses adopt it to show strong corporate governance. Statutory legislative law. The Cadbury Committee released the first edition of the UK Corporate Governance Code in 1992. The governance of corporations is the responsibility of the boards of directors. It is the shareholders' responsibility to choose the directors and auditors and to ensure that a suitable governance framework is in place. Board leadership and company purpose. A successful firm is managed by an effective and enterprising board, whose duty is to promote long-term success, generate wealth for shareholders, and contribute to society. B. The board should set the company's purpose, values, and strategy and ensure they correspond with its culture. All directors must operate with honesty and foster the ideal culture. Statutory legislative law. C. The board should guarantee the firm has the resources to accomplish its goals and monitor success. The board should implement appropriate and effective controls to evaluate and manage risk. D. The board should guarantee effective interaction with shareholders and stakeholders to satisfy the company's duties. E. The board should ensure employee policies and practices support the company's long-term growth. Worker concerns should be raised. Division of responsibilities. F. The chair leads the board and oversees its firm direction. They should show impartial judgment and encourage free discourse. The chair supports constructive board interactions, the effective input of all non-executive directors, and accurate, timely, clear information for directors. G. The board should include a proper mix of executive and non-executive, including independent non-executive directors so no one or small group dominates decision-making. The board's leadership and the company's executive leadership should have defined roles. Non-executive directors need enough time to fulfill their duties. They should confront, guide, advise, and keep management accountable. The board, with the company secretary's cooperation, should have the policies, procedures, information, time, and resources it needs to work successfully and efficiently. Statutory legislative law. Composition, succession and evaluation. Board appointments should follow a systematic, thorough, and open method, and the board and senior management should have a succession plan. Appointments and succession plans should be based on merit and objective and foster gender, social, ethnic, cognitive, and personal diversity. The board and committees need skills, experience, and expertise. Consideration should be given to the length of service of the board as a whole and membership regularly refreshed. Annual board evaluations should evaluate composition, diversity, and teamwork. Each director's performance should be evaluated. Audit, risk and internal control. The board should create clear, public rules and processes to assure internal and external audit independence and effectiveness and financial and narrative statement integrity. The board should be fair, impartial, and comprehensible about the company's condition and future. The board should set processes to manage risk, supervise the internal control system, and assess the company's long-term strategic risks. Statutory legislative law. Remuneration. Remuneration policies and practices should support strategy and long-term performance. Executive compensation should be connected with corporate mission and values and tied to long-term strategy. A formal and open method for determining director and senior management remuneration should be developed. Directors shouldn't decide their own pay. Directors should use independent judgment and discretion when authorizing pay, taking business and individual performance into consideration. Common equity law. The law of England and Wales may be characterized as a set of regulations, some of which are established by legislation and others which have developed over the course of centuries as a result of court rulings. The latter is based on the legal precedents or regulations created as a result of these instances and is known as the country's common law. The third source of law in England is called equity, and it acts as a complement to English law by stepping in to strengthen its application in cases when the outcome would be unfair or unjust. Common equity law. The equitable principles. Equitable principles are presented as legal maxims, reflecting their flexible application. They are flexible and don't cover everything. Maxims include: equity considers that to be done what should be done. Equity won't allow a wrong to continue without a fix. Equality is equity, equity enjoys equality. To get equality, one must act ethically. Equity benefits the watchful, not the passive. Equity presumes the performance of a commitment. Equitability detests a forfeiture. Equity does not need a pointless act. Anyone entering equities must do so with clean hands. Equity takes pleasure in carrying out justice fully. Equity will assume jurisdiction to prevent a proliferation of lawsuits. Equity adheres to the law. Equity won't help a volunteer. Tort civil law. Tort law covers civil rights, responsibilities, and remedies. It helps folks who've been wronged or injured by others. A tort is a civil violation by the tortfeasor that unjustly harms another. The tortfeasor becomes responsible. Tort law is handled by civil courts, unlike criminal and contract law. Elements of the law of tort. Negligence. Despite the fact that there are other sorts of torts, carelessness is by far the most frequent one for which plaintiffs file lawsuits. The negligence tort is composed of 4 parts. Duty of care. A legal duty of care must have been owed by the defendant to the claimant in a negligence case. Breach of duty. The defendant must have broken their duty of care to be negligent. The reasonable man test is used to determine breach of duty. This objective test asked whether the defendant's behavior fell below that of a reasonable man. Causation. Once a violation of legal duty of care is proven, it must be demonstrated that loss, damage, or personal harm resulted, directly or indirectly. Harm or injury. Once a violation of legal duty of care is proven, it must be demonstrated that loss, damage, or personal harm resulted, directly or indirectly. Tort civil law. Economic torts. Economic torts cause financial loss. An example of an economic tort is passing off in business, when a person or company tries to pass off their products as those of another, depending on the original product's goodwill. Claim damages for economic loss. Other claims in tort. Other tortious grounds include trespass, invasion of privacy, defamation, occupier's responsibility, and nuisance. Summary. Company law includes company governance and corporate finance. Corporate governance in the UK binds shareholders, workers, creditors, and directors. Corporate governance is how corporations are managed. The Cadbury Committee released the first edition of the UK Corporate Governance Code in 1992. The third source of law in England is called equity, and it acts as a complement to English law by stepping in to strengthen its application in cases when the outcome would be unfair or unjust. Tort law covers civil rights, responsibilities, and remedies. It helps folks who've been wronged or injured by other